All right, welcome everyone. We'll go ahead and call to order the special meeting of the Planning Commission for Whitefish, Tuesday, May 5th, 2026. Happy Cinco de Mayo. Thank you all for being here. Do we have any agenda changes tonight? Okay, seeing none. Communications from the public. So this is a time for anything that's not on the agenda. We have 2 items tonight. So if there's anything you'd like to address, please come to the podium and state your name and whatever you'd like to let us know. And I still have quite an echo. Thank you, Alan. And last time they said, keep talking, so. I'm trying to think of what to talk about. We were just debating where the holiday Cinco de Mayo originated and what it is, actually. Okay, does that sound any better to the audience? Sounds better. Thank you. All right. Any communication from the public? General comments? Seeing none, we'll close that. Unfinished business? I don't think we have any tonight other than what we're doing. Well, everything we're doing is unfinished business tonight. Yeah, so. All right, so we have 2 public hearings tonight. Seeing that there aren't many people in the audience and there's no one here who was not here for the prior time, I think it's all right if we totally skip the staff report. Is that
Yeah,
okay
I just
with
was
you
going
guys?
to cover some of the public comments from last time, just some response to some of those, and then other than that, yeah, I don't need to regurgitate the staff reports.
You want to cover the
Yeah, I just have
public
a couple
comments?
things to address some of the public comment that came last week. Number one, I mean, again, all these changes are to implement MLUPA. They're not to implement our Vision Whitefish 2045 plan. All those changes are coming towards the end of the summer is when the contract, whenever we get the RFP out and get some qualified firms to apply for that, then we'll start the second phase of our zoning that will implement that, which will include changes to the zoning maps. You know, this is not changing any of the zoning maps, it's just changing the text. For instance, you know, the WR4 zone, there's many areas of it throughout the city. There's a map that I provided you guys that shows you all the different areas that are WR4. There's not a one-size-fits-all to change the densities on that because it will affect a lot of different areas, you know, apart from the Lupfer neighborhood, including the Depot Park Townhomes, which is a city snow lot contract that's currently building out to its allowed density. There's a bunch of properties on the other side of the viaduct that are all WR4. It's our highest density residential zoning district. And it's been that way in those same locations since 1982. It used to have no limit on the number of units there. We added a limit when we started the Legacy Homes program in 2019 so that we could capture them and require them to provide affordable housing. When the state got rid of that, you know, it was no longer needed. And so, but the current limits on that right now were set in zoning. They've been that way for a little bit. As far as the professional offices and personal services, right now on major arterials, which include Wisconsin, Central Avenue, Spokane Avenue, and Highway 93 West, in the high-density residential zones, which include R3 and R4, those uses are an administrative CUP right now, which means we just notify the neighbors, but then staff approves it and places conditions on there. In the 20 years I've been here, we've never denied one that's come forward. Only a couple of them we've ever had to add special conditions to, like maybe put a fence up or pave a driveway. And those same conditions are ones that we would continue to do. And the direction that we had is to, you know, make those into permitted uses, and then all the ones that were regular conditional use permits for the most part, we moved into administrative conditional uses. At the last meeting, Mr. Hildner made a comment about changing the accessory building setbacks. We are not changing those. They've been exactly the same since 2005. So accessory buildings have a 6-foot setback, and that has not changed. It's not changing. The only thing that we were recommended changes is in those certain suburban zoning districts where the side yard setback would be changed from a 15-foot setback to a 10-foot setback, which matches the equivalent county zoning. Because over the years, we've had issues with people annexing in, and then suddenly Whitefish's side yard setback is more restrictive, and they built their house to a certain standard, and now their house is non-conforming. Every other side setback in our residential zones is 10 feet, so we're recommending changing that to 10 feet to match that and to match the county to get rid of that anomaly. And there was a comment about our subdivision regulations with regard to phasing, and subdivisions are typically phased, especially large ones. There's multiple phases because it costs a lot to put in all the infrastructure. And so when if the first phase goes in, those lots sell, they use the money from those first lots to build the second phase or a third phase. But they have to, when they do a subdivision, they have to come with a phasing plan up front so that we know that, and then we can figure out how to make them bond or build out the infrastructure that's needed for a phasing plan. I just wanted to address those specific things, but other than that, if you have any other questions about anything, I'd be glad to answer them. And I also provided you guys a little flow chart that we are putting in our public participation plan that just shows how permitting will occur and when we notice the neighbors.
All right, thank you for that, Dave. At this point, unless there are questions for staff directly, we'll open public comment.
The only questions I have can wait until after public comment.
All right, so this public comment period will encompass both item 1 and item 2 on the agenda. You can comment on either, both together, separately, as you wish. There's so few people here. Say whatever you're thinking. Please let us know. So this is public comment for WZTA 26-01 and WSUB 26-01. So go ahead, come up, state your name and address, and give us your public comment.
I'm John Heberling, 42 Crane Marsh Way, Whitefish, member of the Board of Citizens for Better Flathead. I'll start with the 60-foot buildings. The changes proposed by staff are changes to accommodate 60-foot buildings downtown and some other places. The 60-foot buildings are not in Emilupa. They don't have a May 17 deadline. In fact, the deadline for complying and setting up whatever system will be used for 60-foot buildings in Whitefish is October 1st. So last meeting, Frank mentioned that there are several members or many members of the city council who do not want 60-foot buildings downtown, and I think we need to give the city council and the city some more time to accommodate them. We don't have to begin to accommodate them until October 1st. So I don't think it's a good idea to accommodate them now, because if these regulations pass city council, then 30 days after that, the 60-foot buildings would be allowed, I think. They have to be allowed in certain places, but not until October 1st. So I think we ought to give the city the chance to prepare a strategy for that. So in my comments, I suggested striking all references to 60-foot buildings for now. We're going to have to deal with this at least in September, so that it's done by October 1st. But I think the city wants to, does best to establish a strategy for that. Then in the staff proposals, page 21 and 22, there's discussion of WR4, and there's permitted uses and conditional uses, the 18-unit family dwelling appears in both. It does not appear for the look-for area, for example, in the land use chapter. So what the staff is proposing is not consistent with the community plan. The community plan would allow them along Spokane and Baker, but the staff is adding on, allowing them along Central and Wisconsin south of Skiles. So that's not consistent with the community plan that the city council just approved. So those two additions, meaning Central and Wisconsin, should be stricken. Then permitted uses. Under MLUPA, they talk about proposed developments. And this would apply to any building project. There isn't a good definition of proposed development, but the result of MLUPA Section 305 is that the zoning administrator can approve, deny, or approve with conditions. So in doing so, attaching conditions makes it conditional. Also, it's conditional on approval, so if he denies it, that makes it all the more conditional. So everything should be treated as a conditional use. And so I've suggested striking permitted uses. Then there's a suggestion by the staff to change the concurrency language. The planning board passed concurrency, the city council also passed it, and the staff is suggesting concurrency, quote, or phased. And I think Dave just referenced that. But or phased waters down the language and makes it open. So it needs to be, if there's some kind of phasing, it would have to be much more carefully drafted. As it stands, we should stick with what the city council passed, which requires concurrency. So that's been my suggestion. And there's something in these suggestions which also has nothing to do with MLUPA, which was to change the appointment of the planning administrator from city council to eliminating the words by the city council. So it would be appointment in some other way. And I'm suggesting that the most democratic way to appoint the zoning administrator, very important position, is to stick with the most democratic way. The city council people are elected, and I think they should make that decision. Then there's another place where says in the staff proposals says that there must be compliance with the goals and objectives of the community plan, but the community plan is greater than just the goals and objectives. The old section said there had to be compliance with the growth plan. That's fine. In fact, that's what MLUPA says. Well, actually, it's a section outside MLUPA that says that. So there's more to the community plan than just the goals and objectives, especially in the land use chapter. There are a lot of height restrictions and use restrictions that are very important and should be enforced. So the zoning administrator should be enforcing the whole community plan, not just the goals and objectives. Then there's a problem with just 15 days notice that the zoning administrator is going to consider impacts of a proposal. So right now, MLUPA requires 15 days notice. But MLUPA doesn't prohibit giving better notice than that. In fact, the Constitution probably requires more than just 15 days of notice. So I'm suggesting in my comments that right at the very beginning, when the developer submits the application, a notice should go up on the website and at the project site that this project has been applied for. So that's long before the application is complete and the zoning administrator makes a determination on whether impacts have been considered. And that's when the notice goes out under the existing regulations. But I'm saying to give early notice all the way back when the application is filed so that people will have more time to react to it. 15 days isn't much, especially if it's a major project and you want to consult experts about environmental impacts or something. 15 days isn't much. So that could be expanded without violating MLUPA. And then also I talk about not just having newspaper notice for an appeal from zoning administrator to planning commission or planning commission to city council. Right now, the regulations as proposed by the staff go for just newspaper notice, and I'm saying it should be on the website, on the property, and mailing to 300 the people within 300 feet. Lastly, another thing I suggested was that there be a public hearing before the zoning administrator when he's making the initial land use decision. That's going to be a decision of significant interest in many cases, and there should be a public hearing. This is probably required by the Constitution. If a matter is, quote, of significant public interest, then Article 2, Section 8 of the Constitution requires a public hearing. So it's not required by MLUPA. MLUPA is silent on that. It doesn't prohibit a public hearing. So I think the city should have one because, frankly, that's an easy lawsuit if there is no public hearing. So thank you for the time, and I appreciate all that you do.
Thank you, John. Next public comment, please.
Good evening. Rhonda Fitzgerald, Lupfer Avenue. At the last week at the meeting, I went into great detail about the Heritage Urban Neighborhood, which is a place type now that includes the historic neighborhood south and west of downtown, as well as the neighborhood east of downtown. And I went into great detail that I don't want to repeat again, except Andy wasn't here. Did you have a chance to look at the YouTube? So I don't need to. Thank you. I just want to highlight that in the WR4, which that neighborhood is incorrectly zoned as currently, there are conditional uses for some of the streets that include personal services, professional artist studios, and professional offices. These have nothing to do with housing. And they're conditional uses on Spokane Avenue, Central Avenue, Baker Avenue, and Wisconsin Avenue. Those have been moved into permitted uses, even though that's completely inconsistent with the place type that's designated for those streets except Wisconsin. So I think it would be much better in the long run to leave those as conditional uses. My understanding is they are not administrative currently, because I know that when there's a conditional use on Spokane Avenue, I get a notice. So they're not administrative at this time. And I think putting them back into conditional for the next several months until the zoning can be completely updated to align with the new community plan gives those streets, those neighborhoods, some predictability that otherwise they're kind of vulnerable for 6 months until it gets fixed. And Central Avenue, south of 4th Street, is not at all appropriate to have those uses. It doesn't have them. It's a residential area. And so the Central Avenue phrase there should be stricken from those 3 different uses entirely. And then hopefully those 3 can go back into conditional for the time being, which is just the status quo until it's rectified. To move them into permitted seems going in the wrong direction to me because they shouldn't even be on some of those streets. And Spokane Avenue is its own beast. It's highly historic, identified in many cultural inventories, needs a special treatment. And I just really hope that you could be sensitive to the issue there. And when the zoning was first adopted in the 80s, those neighborhoods were struggling. And since then, you know, things have changed quite a bit in Whitefish, and one of the things that's good that's changed is that people want to live close into downtown in walkable neighborhoods with modest homes. And I think it's important to recognize that. These are not degrading neighborhoods where you need to start inserting other uses into the neighborhood because they're desirable to live in. The people who live there have lived there a long time, many of them. Other people want to live there, and I think we would want to preserve that resource. So I hope that you can move those back out of permitted and into conditional, and then I hope that you will, the sooner the better, to actually fix all of this zoning to align with the community plan, because the place types, there's a grid in the resource document that has the place types and which zones those should align with, and this is wildly out of alignment. So thank you very much.
Thank you, Rhonda. Further public comment?
Richard Dillner, 104 5th Street, Whitefish. And I'll make it short and sweet. I think, or I hope you will support, because I do, the comments made by both John and Rhonda. And I have several comments that I could make about fire, but I won't. But I think that I would make one comment, in that in Appendix B, the HIZ, or home ignition zone, is way out of date. That has changed considerably since that was first published. And at some point, somebody needs to take a look at that. And I'm sure that the comment that will come back we'll take care of it with the CWPP, Community Wildfire Prevention Plan, but I don't hold out a whole lot of hope that there will be a complete review there. So thank you, and thanks for everybody being here.
Thank you, Richard. Further public comment? All right. I just have a question. There's on our desk a comment from Shelter Whitefish, but when I opened the public comment, was there anything in the public comment folder today? It said empty for me.
So the public comment folder was not under the subdivision or the zoning, but under the main chapter,
Yeah.
the main folder where the minutes were. And there's a folder there that, a lot of these comments came in today, so we put them in there this afternoon.
Okay, I looked, this afternoon, and it said empty, but I may have looked
They're
at
definitely in there, they were in there this afternoon.
something wrong. Did anybody?
I read them this afternoon.
Okay, so, and I don't know what to do about that, but anything that was submitted today, the
Well, that's why we put
majority-
copies on the table, because those are all the comments that came in, and almost all of those came in today.
Yeah, so we have no time to read them, so I guess that's just,
Anytime
Just-
comments are, that meeting was scheduled before, but our comment period was
yeah.
last week when we had the
Okay.
meeting, but we did forward everything to you. you know, assuming that most people read the stuff in those folders last week, and so they weren't looking in them again. So that's why we made copies for you. It's our
Okay.
standard procedure with the planning commission.
Okay, thank you, Dave. All right, go ahead.
Yeah, Keegan Stephen Aller, 306 Lutfer Avenue. I just wanted to summarize in case people didn't get a chance to read the public comment. The first comment is basically just addressing the concern about reducing setbacks as being a fire risk. And I thought it would be useful for council to have some research on kind of what types of housing do create fire risk. And the biggest fire risk in a place like this that has a lot of urban wildland interface is sprawl, right? And it's leapfrog development and it's single family homes. And if you look at rate of fire deaths in addition to like amount of structures that burn, that leapfrog development and those single family homes are much, much worse for that. So that comment is just basically describing that research and saying the density within the city, if you actually look at the amount of people that die in fires or the amount of structures that are burned, it's much more important that we build densely than build sprawl. And that's a very big fire consideration. And then the second comment is just around kind of the downzoning of Lutfer Avenue and basically saying that, you know, it's clear that if you probably polled everybody on Lutfer Avenue, they would say that that area shouldn't change at all. And the point of the comment that I made is that Shelter WF is an organization and the people we represent, we come in to say that existing residents are not the only voice that matters. They might be the only voice that has been valued for a long time, but they're not the only voice that matters, and decisions that benefit existing residents can hurt the city as a whole and can hurt the people that are the least well off. And so I hope that council will consider that and not just the opinions of existing residents who will always want to kind of protect the exact situation that they've had for a while. So just wanted to summarize those in case anyone didn't have a chance to read them. Thank you.
Thank you, Keegan. Sorry, I missed that totally today. I don't know how. I did not get into the correct folder. It just said empty, and I thought, all right. Okay. All right. So, anybody, we don't have anybody online, do we? No. Okay. Thank goodness. So, close? Yeah, I think so. So we're going to go ahead and close the public comment at this point. And yes, you may.
Normally I wouldn't ask this, but because I went to the agenda, I clicked on the highlighted WTZA agenda item. I opened that screen. It said public comment. I clicked on it, and it said empty. So, hey, and if I had read that comment that just attacked my neighbors, I would definitely have included a comment in my public comment, which is that all different types of people live in these downtown neighborhoods. Some new, some there a long time, and they are citizens of the community. And to denigrate them is completely inappropriate. Thank you.
Thank you, Rhonda. All right. So now we will close the public comment. Thank you. All right. So I will turn to the commission for any motions that you would like to make. Last time we requested to have these lined out and go through. Obviously, we'll begin with the WZTA 26-01. So we'll just start and go through anything that somebody would like to make a motion about. Go ahead and start.
Well, I'll start. Thank you. I'd like to make a motion to eliminate all of 11-2I-2 permitted uses. I believe that the term permissible uses does not appear in MLUPA, as John had said, referenced. Under MLUPA 76-25-305, all proposed developments are subject to conditions. This makes all uses conditional uses. Clearly, all proposed developments are subject to an impacts analysis and imposition of conditions for approval. Likewise, all proposed developments are subject to being denied. This makes them even more conditional. Certain uses are permissible in each zone and are subject to conditions. No proposed developments have greater entitlement as is implied by a separate category of permissible uses. All uses are equal and are equally subject to conditions. All uses may be called conditional uses. The permissible uses section at page 21 should be eliminated.
I'll second that motion. We can discuss before voting, if anybody would like to discuss.
Sorry, I have a backtrack here. What page is this on?
21.
21. Okay, thank you.
So page 21 is a permitted uses for a specific zone district. So are you proposing to eliminate this term from all zone districts or just the one on that page?
It's one on that page.
Okay. That is in WR4, excuse me. Okay, so that is what his motion is.
Yeah, and that's the map that we have, that staff provided today. So WR4, we can see it on this map. Adding all of these as permitted uses instead of conditional uses is quite a change. These are pretty large chunks of the city, so I support this motion. Any further comment?
I would just I am Angie tonight, but I do want to caution you on this. The proposed changes that are in front of the board, there are some items that did move from conditional to permitted, but if you are eliminating all permitted uses, I don't think this was really noticed that way, and I would caution such a significant change to our zoning to actually hold a public hearing to make that significant change, because that is not as simple as, because remember, we don't have the full zoning updated yet. That was going to be part 2 where we would look at those. I don't think that we're not in compliance with MLUPA by having permitted and conditional. Permitted ones will still go through the typical review of confirming if it goes through the land use. Conditional just means that there's going to be more conditions likely added. So in my opinion, I would caution you on doing such a wholesale change without the public being noticed on going from basically having permitted uses to no permitted uses in the city of Whitefish.
And just in addition to that, there's several things that state law requires us to, as permitted uses, such as daycares, type 1 residential facilities. That motion would require every single building permit that's issued in the city, and we get, dozens of them a month that have to go through some other additional process where we notify all the neighbors, which we've never done, and be a significant burden on staff. Other types of uses like public facilities, home occupations, other things that are right now are just permitted uses in residential zones would then have to go to a much more rigorous process for approval.
So Dana, saying that we would have to notice separately, what would that look like?
In my opinion, we would go through the normal process for updating zoning. So it would be a whole different proposal. I also think we need some legal clarification on if that is even what the intent of the law is. If it reads that way, sure, but I do see within here where there is the ability for cities to have conditional uses, so that means all other uses would be permitted uses. So that's my concern, is if we have ones that we can put conditions on, then you have ones that you don't put conditions on. For example, right now, high-density residential in commercial zones, we get no control over that. That's use by right, and that is in state law. You move everything out of permitted right now without going through state law and all the different things that are permitted by right because of state law, you're gonna cause us to be non-compliant with other parts of state law. I think this takes a lot more work, which is why it's part of the second zoning update.
I guess this is a bit confusing to me as we go through this process as to when, yes, we may change this, or no, this has to stay like this until later, and then it can change. I need some clarification on if this is something that would happen 2 zoning processes from now, then what does that look like?
So we're gonna go through the same process we just went through, but we'll be hiring a consultant to help us go through, make sure that the zoning as a whole is compliant with our land use plan and the map itself. This is the biggest change that we have to make right now is how developments are approved. We are going in front of the legislature at the end of this month, and they're asking our status of every community that has to comply. And so we want to make sure that we at least can say that we have taken the steps to adopt the land use plan, that we have made the steps to make sure that we are not holding the public hearings that in their eyes we're delaying the process for development. When it comes to having everything match exactly, we're gonna be able to share, like, that is a huge undertaking for a full rewrite of our zoning code, especially going to a place type map. And so with that, like, that's where that second round comes around. So for the fiscal year 27 budget, we have money that has been designated to hire a consultant to help us. So we can get that RFP out. Once this process is done and it's gone through council, we'll start with the RFP. We'll hire somebody so that July 1, summertime, they can come on. We can start working on that. And then we'll have the same where it comes before you. That one's gonna take a little bit more work. This one, the reason we didn't hold work sessions on this was that this really is a state law fix to comply with MLUPA when it comes to approvals. In the future, though, there's a lot more discussion that can happen on the second round of zoning updates, because that is a bigger rewrite. There'll be, whether we have permitted or conditional, we'll have to determine if those are the right terms used, or are we gonna have different terminology to make it seem more consistent, but I do believe that you can still leave it as is right now. And I would caution you again that you would have to go through a noticing period, because I can only imagine that we will be a target of lawsuits if all of a sudden every use in Whitefish is conditional.
So I understand that this is a step-by-step process. I'm just having a hard time understanding what we have the ability to change now under the public notice that we've given, and this is our second public meeting on this. And so to hear changing that is too much and you would have to renotice, I'm confused about how much we are able to do tonight. Is that like change one word from church to parsonage, or what are we able to do tonight?
My suggestion is to look at what edits staff has proposed, and you decide to keep or not keep the proposed edits that staff has made.
But deciding to not keep the proposed edits, so to change from page 21 to 22, those edits, if we change those edits, that's too much. Does that make sense? Does everybody
the motion was
see
to
those
change
two?
all permitted uses out of the WR4 zone and move them all into conditional uses, including single-family homes, including daycares, including other things that are required by state law to be a permitted use. If you want to change some more specific things, like moving the personal services and professional offices out of that zone back into conditional use permit, then it's not a major change because it's what it is right now. But adding things, if every single builder in town finds out that they have to go through a conditional use permit to get a building permit for their single family house, that's something that the public needs to be notified of.
So to keep the blue and get rid of the red, so page 21, if, instead of using the language, get rid of all permitted uses and go back to conditional uses, if we said the red is what we do not like, and we make a motion to go back to the blue as it was in conditional uses, is that too much, or is that permitted?
I mean, there's certain of those uses that we moved in there because state law required them based on different laws that were passed, including, you know, type 1 residential facilities, foster homes, daycares. All those things are required to be permitted uses under the state law. So that's why we moved those into that zone, to be compliant with state law. And then the other changes were ones that, you know, out of our work session with the city council were recommended to be moved, and that's why they were moved.
All right, so we'll go through then in a more piecemeal way on these 2 pages to see what motions we can make to eliminate some of the permitted uses and put them back into conditional uses. Does that sound agreeable?
Yes, if you're
Okay.
talking about the red lines that are proposed, that you say, no, we do not want churches as a permitted use, we want those back into conditional, then that is fine. It might violate state law on some of them, but you are a recommendation body, you are a decision-making body, and we can explain that to council.
Did MLUPA require churches be placed? This is where I think it's difficult, is these are very specific things that MLUPA is requiring, and it's difficult to say what makes sense in these residential areas and what does not.
And
Any-
the staff report outlined which state laws and which things were needed to be moved, if you read through that.
Any comment on this before we go through motion by motion on these changes?
It seemed to me that it was the personal services, the artist studios, and the offices that had been moved that were an administrative CUP that are now just moved into permitted uses. It seems like that's the source of the controversy about this. So just taking those 3 and bumping them back to what they were beforehand would not really change anything, but maybe be sort of put people's minds at ease. Does that
Correct.
sound right? Yeah.
Would you like to make that motion?
Sure. I'll motion to put personal services, professional artist studios, and professional offices, remove those from the permitted uses and add them back to the conditional uses like they were before.
I'll second that. Any discussion? I seconded. Yes, thank you, Michelle, sorry. All right, all in favor?
Again, and that's just the WR4 zone, correct?
Yes. Okay. All-
Just,
Go
sorry.
ahead, Mike.
In WR4, I want to be a little careful about what we are scrubbing out of here. The WR4 district is intended for higher density residential purposes and for limited non-residential uses that are compatible with such a residential setting. So this is the place for those, this is the zone. And whether or not that zone will change, that's another story, but this is the zone for those activities. Moving them back to administrative CUP probably just puts a touch more work onto the staff, or it allows them to not, or doesn't allow them to save the work of having it be a permitted use. Dave, would you like to add to that?
I mean, that's just how we do them right now. We send a notice out. You know, we rarely ever get comments. That's why you see so many commercial uses on Spokane Avenue, and there's a couple on Central. Because those businesses come and go in those, and a lot of people, because of the high traffic along there, the people don't want to necessarily live there, or they're rental units if they are, so.
So moving these back to conditional use is not going to be a big burden to the staff?
Not big, not a huge deal.
Okay, thank you.
All right, all in favor? Okay, so all opposed? Mallory opposed, everyone else for? All right, and I would like to make a motion in conjunction with this, now that we have moved these things back to conditional use, to strike Central Avenue south of 4th Street, because that area is definitely not, it's a residential area.
There are two.
So that's the motion, to strike the language under personal services and artist, in this whole grouping that we just did, these three things. Central Avenue south of 4th Street, that section I moved to strike because that is a purely residential area.
And when there's a hair salon in there, and there were some other offices in there that may have moved, but.
Yeah, and those are sort of grandfathered, I mean, they're already there, but on the whole, that's a historic, purely residential area, very different from Spokane and Baker. Central is quite different, north and south, so. Is there a second to this motion? Okay, thank you, Phil. Any discussion? All right, all in favor of striking Central Avenue south of 4th Street from these three bullet points on conditional uses, raise your hand. All opposed? All right, the motion fails. 4-2. Okay. Next motion or issue, please.
This might become a motion, but it's for the moment a question. Page 26 of the PDF, page 19 of the document. Why are the various light commercial uses, personal services, studio gallery, the same things we just talked about, added to permitted uses in WR3 if the intent and purpose only mentions residential in WR3?
So you're talking about the same ones that we just talked about? Why are they
Same ones we just talked about, but in the WR3.
Yep, so there's areas in the WR3, like Highway 93 West, that allow professional offices and personal services, and you'll notice there's quite a few of them out there, as well as on Wisconsin Avenue. Same purpose, we were directed, to move the administrative ones into the permitted uses, and just because they're, again, we rarely have comments about those things, and we still have standards for them in the code to be able to review them, criteria, because we still have to issue a business license and or sign permits and or building permit if they have to do a remodel.
Okay, well,
So-
we're not, and I understand we're not rewriting the zoning currently.
Yep.
It's just that the intent and the purpose seem a little bit disconnected with the actual, like making it a permitted use as opposed to a conditional use, just because it doesn't mention any light commercial or limited non-residential was the term used in WR4.
Right.
And it's not
Yeah,
used in
'cause,
WR3.
yeah, the R4 is more condensed to the downtown, but the R3 still is found on major arterials, which is the areas where the only areas those things are allowed, which is Wisconsin Avenue, 2nd Street, which is Highway 93 West.
Okay, so maybe this just gets looked at in the major rezone, just making that intent and purpose a little broader, or whatever change is necessary to bring those two things into agreement. It's not for now. Thank you. No motion.
All right, further motions? Go ahead, Phil.
Sorry about, motion to strike on page 28, maximum height, and remove the red lines, because we don't need to have 60 feet until the fall. Keep it at 35.
I'll second that. And I'll also speak to it. Listening to the last council meeting that addressed anything to do with 60-foot buildings, there's so much confusion as to where and how it should be worded, and even confusion about if the first floor is commercial and the second floor is this, then can the third and fourth floor be potentially short-term rentals? There's a lot happening around these 60-foot buildings that I think the longer time we have to talk about it, the better we're going to be able to put them in spaces that they actually make sense. They provide the housing that we need, and they're not just something that is added in because it can be, before we really think about where it makes sense to have them. So I support this.
Can I just
Dave,
make a
oh, sorry.
quick comment as why they're in this now? I mean, they do have to go into effect by October 1st, but in order to get that in the code by October 1st, they would have to be on the July 16th Planning Commission meeting, based on the schedule of when it goes to the City Council for 2 meetings, and then goes 30 days before it goes into effect. And we just knew we weren't going to be bringing, we weren't going to have time to address this, and they're not going to be available to do this in the second round of zoning. So we're doing it in the first round so we can come into compliance with state law. And that's why it's in here now. Well, technically, we're not required to do it till October 1st. You know, there's very little chance with the, you know, with Wendy gone and just 2 planning staff members that can do current planning and the stuff that's going to be coming in over the next couple months, that we'd be able to address it. So we put it in now to take care of it.
I have faith in the consultant that you're going to hire.
We don't have a consultant, and they probably won't be on
But you
board
said
till, because we have to put it out for RFP for the second phase of it. So we may not have them even on board after we do all the interviews or anything till August, so.
Okay. I still support removing it and then adding it back in as we can. I know that time is tight, but it can be carved out. This interim period, though, is a time when things will happen that we need to be very cautious about where and why and how. So if October 1st is the date by which we have to have this right, then I don't support it being in this document now. That's going to have to go through multiple other revisions before we're done.
Dave, I have a question. Is that, so with that change, wanting to do it now, is that the same with HB 482, the parking bill? Because that one, I think, is also supposed to be implemented by this fall as well. Is that
Yeah.
correct?
Yeah, I think so, yeah.
Okay.
Yeah, it's just, you know, these are all, we put together all the changes for state law now. No, and we could have done it last year when we did the change, but we wanted to wait as long as we could on the building height stuff, and then try to figure out ways if what we can address, and if we can address it when we do our zoning update. But I mean, you know, with this going into effect on July 1st, and how long it takes to design a building that's 60 feet high. There's no way that one's gonna be coming in here before the fall anyway, so.
Any further comments?
I'm just curious, Dana, you might, or Dave, either of you might be able to speak to this, but is there, I mean, any intent, or maybe even Andy could, like, by city council to address these 60-foot buildings between now and July? Like, would something change in between now and then that might, I don't know, make it worth it to kick the can down the road for another 2 months or so? Or is it probably just going to be the same
I mean, this is
Just
just for
facing
them
the
a
same
fix to
thing
bring
only
us into
in
compliance. I mean,
July?
you know, with the council, when it comes to them, they could talk to Angie about whether we could put a clause in that that doesn't go into effect till October 1st. Suggested that on something else, and then like on the noticing requirement that goes away in a year, and suggested that we just have to come back and change the code at that point. But, you know, we have to time it with all of the stuff that we have going on and being able to notice it and bring it to meetings and everything, which is why we put it in there this round. But, you know, we're hoping that, I mean, this, you know, only applies to fully, you know, residential buildings, which would be multifamily and ground floor mixed use with multifamily above. And, you know, whether or not anyone's gonna wanna do one of those kind of buildings with that height, who knows, right? I mean, I think it's over time, some of those might come into play, but I don't think anybody's scrambling. You know, it costs a lot more money to build over a certain height where you have to put elevators in and do a different kind of fire rating and all that stuff, which is why you don't see a lot of those big, tall buildings, even in the bigger cities that allow it.
I'll just add, if you do remove it, I mean, council will take a look at this document and we'll inform them that that's not in there. We haven't gotten direction yet from council on how to proceed. Their options are accept it or go to litigation is how I imagine where we're going. I don't think we'll win a lawsuit at all for this bill. It's not one of the bills that like went through some weird public noticing process that you can maybe get them on procedure. That's like the only way that you're really gonna get them to revert this law. I have no work sessions before June 15th, and June 15th is actually booked, so, and July 6th, I don't know. July 20th is booked. We're looking at work sessions into late August. There's no way that we could get a specific work session with council on this topic before the time that it has to get to the planning commission on July 16th. And so I would say do whatever you guys want to do, and we'll bring this topic to council because they're really going to ultimately be the ones to give us direction of, do you want it addressed now or not? I know that's kind of a cop-out for you guys, but I really think that I need the whole council to give me direction on how to proceed.
Go ahead, Mike.
Dave, this is regarding the wording of this. I believe I know what the intent is, and having read the statute itself and then reading this. Obviously, 60 foot for entirely multifamily residential buildings is straightforward. No doubt about what that is. The mixed-use buildings, when any floor above the ground floor is used entirely for multifamily residential, should that read when all floors above the ground floor? Is that what the intent of that? Because any floor could indicate that they would just, floor 5 is residential.
Yeah, I mean,
floor
all
4
is probably better wording.
Okay. To protect.
Yep.
Yeah.
That's a
And
good
that was
catch.
one of the questions that came up at council, was if you had ground floor commercial and one floor of actual residential, then would that leave another floor or two or more for short-term rentals because it's within that area? So this is very contentious, and I understand this will go to council May 18th. There may not be a work session on it, but we can still send a recommendation. They'll have a record of our discussion and can decide from there I think. Any further discussion before we vote?
Just one,
I'll-
Andy, please.
Andy,
I'll just
go
wait a little
ahead.
bit. I'm here more observing and as a vote and a warm body in a seat, because I want to see you guys do your work. But I think from the council's perspective, if you looked at what we did when we reinserted or the language that tried to deal with 60-foot buildings, that was really in downtown, in the WB3 and primarily in the core of downtown. I think we're all aware that we're going to ultimately have to live with 60-foot buildings in the WB2, and that motion, as I understand it, that's on the table right now, is in the WB2. So that was a specific page that you referenced, I think, in your motion. So, I mean, my suggestion would be that if we're going to eliminate it out of anything, we would do it out of the WB3. Now, I would say we may as well leave it in the WB2 because we're going to get them there, and that's not a hill we're going to die on, I can guarantee you. So I think we all are very much aware that that's something that we're going to have to live with, and I think that, you know, but I could see eliminating it if we want to send that message to council from the planning commission to go ahead and pull it out of the WB3 at this point, but I think we should leave it in the WB2. So, and quite frankly, I think given what we have to do, and we know that we have to actually allow them in the WB3, and we would come up with some way to probably mitigate the impact of that, I would probably suggest that we leave it in the WB3 also at this point. And as much as I hate them and I don't like the fact that they're getting shoved down our throat, I think that we are in a position where we do need to comply with state law. I don't like the law, but it doesn't mean that I can then just disregard it, so.
Has there been any discussion by council about this being in effect on October 1st of 2026? And not like an MLUPA thing that says this has to happen by May, this is October 1st. I think that's more the concern that I have is kick the can down the road, like Marty said. Take our time figuring out with the place types that we have, where we must put them, where we don't have to put them, and the fact that we don't have to do anything until October 1st. So WB2, WB3, you know, maybe one, maybe the other, but if we remove it knowing that by October 1st, something has to be fixed, then by that time, we'll be able to translate the place types into zones, and then we can figure out where those 60-foot buildings can go by October 1st. That's my thinking in supporting removing it.
I think if we listen to our planning director and if we listen to Dana and we understand the process that it will take us to get to something by October 1st, the reality is we're seeing it tonight because that's probably the only way we're going to get something in place by October 1st. I mean, I think that's pretty,
Yeah,
Yeah,
and
it's better to have some specific language in here. If we don't have something adopted by October 1st, I mean, do we allow all 60-foot buildings, no matter the uses? I mean, being prescriptive at least gives us some ammunition to at least limit what can be 60 feet, so.
yeah.
Just one additional note, since she's not here. Angie was pretty unequivocal about what we can do and what we can't do in regards to this. And things like redesigning the downtown is clearly going to be seen as a workaround. The two of the four items that Senator Boldman, we agreed with two of the four items, I believe, so to me, I don't want to see 60-foot buildings either, but if they are the types of 60-foot buildings that are residential, the vast majority residential, and if we maybe a subsequent motion, if this doesn't fail, if we leave it in at all, I would like to change that any to all, but that's a separate motion. So that's the direction I think for my take on it.
All right, so we'll go ahead and vote on this motion to remove 60-foot building. What's the page reference on that again? 28? 28? Okay. All right, all in favor? Go ahead.
For clarification, that is just in the WB2, correct?
For this
That's
motion,
page 28,
yes. Yeah. Okay, all in favor? Okay, all opposed? Okay, motion fails, 2-4. All right, Mike, would you go ahead and make your motion to any to all? Thank you.
Yeah, big monster change I'm recommending here. I would like to make a motion in the WB2 and WB3 zoning districts to change the maximum height verbal description for mixed-use buildings when all floors above the ground floor are used entirely for multifamily residential. Changing that from any to all floor, any floor to all floors.
I'll second. Any discussion? Okay, all in favor? Good catch, thank you. Passes unanimously. Yeah.
Dave, sorry, Whitney, can I? Yep. Dave, I just have a question on page 27, under conditional uses. It says manufactured home subdivisions, and I just was looking for a little clarification there, because I know under state law, manufactured homes can't be treated different than stick-built homes. And so I was curious if keeping manufactured home subdivisions under conditional uses, that was already in there, and I was curious, should that be permitted use, or I kind of wanted to have a discussion about that, just so that I understand that better.
Yeah, I mean, we define manufactured homes as a stick-built home, so that's a good catch. We probably just should delete that out of there. I don't know if it's in other places, but.
So could I then, oh, sorry.
Yeah, you can make a motion to delete that.
Okay. Do I make a general motion that if manufactured homes are mentioned, that we?
Yeah, we can do a search to see if that's elsewhere.
So that would be an okay
That is
motion
the
to
only
make.
place, but I'm just double checking.
There are references to manufactured home parks as opposed to manufactured home subdivisions. There, it's manufactured homes is in the document like 12 times, and I don't
Yeah, I mean,
know.
I think the intention of this was like a manufactured home park, because there, there used to be trailer parks in that zone, there still are, that they would have to go through a process. But, recreational vehicle parks is already covered, so as a conditional use, and then we've redetermined what a manufactured home is, so yeah, I mean, I think that you're correct in that.
Okay, so then I'll make a motion to strike manufactured home subdivisions from under conditional uses on 11-2K-3.
And do you want to say anywhere it appears in the document?
Oh, yeah, and anywhere it appears in the document, since manufactured homes are supposed to be treated as site-built or stick-built homes or site-built homes under state law.
That might be the only conditional one, just Mel, so you know, the rest of them are permitted uses.
Yeah, I mean, I think so, but I'll do a double check just to
Okay,
make sure.
so it would be, the motion would be,
So let's start over. Okay, so the motion is to remove any conditional uses for manufactured homes throughout the document.
I'll second that.
Yes, and make them permitted uses.
And I'll second that.
All right, the motion's been made and seconded. All in favor, raise your hand. Okay, passes unanimously. Thank you. All right. I will make a motion. This is page 86 of the document, chapter 7, 11-1- 11-71 enforcement. Here we have stricken by the city council. The zoning administrator duly appointed by the city council, and I move to add back in by the city council. Give everybody a second. Go ahead, Dana.
This is actually in violation of our charter. The city council, under our city charter, which is voted by the citizens of Whitefish, this was talked about at the Local Government Review Commission quite extensively, whether or not this would be a proposed change for the charter. Ultimately, they decided not to put that to the voters. And so the appointment of the zoning administrator, really there is truly appointed, I guess, by me as the city manager. The only appointments that council can make for staff is the city attorney and the city administrator. So they've appointed me, and then I am basically appointing Dave to act as the zoning administrator. Don't know when this was in here and how long it's been in here for, but our charter, I think this is in direct conflict of our charter. And that's why it was talked about at the Local Government Review Commission.
Then I'll rescind that. Since it's you, I totally trust you to appoint the correct person. Thank you, Dana.
The reality is they're gonna, the council can remove the city manager if they aren't happy with, at any meeting. Whereas our planning administrator, there's laws in place for employment. It can't just be because you don't like his decision. But for a city manager, there absolutely is that ability to fire me if you don't like how I speak, how I look, or anything, quite honestly. So.
Well, thank you for staying with us.
Yeah, and we already got enough, bad enough picture painted of us already. We don't want one more thing that people can throw mud at us for.
Nothing else. All right.
Something else to note on that is many communities, the planning director is not the zoning administrator. I've held that role in other places where there was a planning director. So it's not always the, person that's the planning administrator that acts as the zoning administrator.
Thank you. All right. What else?
May I ask a question? I know this is motion time, but it felt
Yes.
weird to ask it right at the beginning when we weren't really in the document. On page 32, there was a section on non-conforming uses that was stricken. I would bet that this was addressed early on in the staff report, but there's a lot of information, and I was just curious why that was cut.
So that was something that the city council put into place specifically for one business that was in existence when we added some language that didn't allow for offices to be with the front part of a storefront on Central Avenue. So the intent, and this came from the Downtown Business District Master Plan, that along Central Avenue between Railway Street and 4th Avenue, that it'd all be retail along there, and we didn't want like a realty office on the ground floor, but we wanted to have it, be inviting so that people would go in there. Well, there was an existing business with a law firm at the time, and they petitioned the council to, put this language in there and we already have language in there that if it's an existing non-conforming use that it can remain, and it was already there and it can remain. So this was like a redundant thing that was added to the code back in the day, and it's really no longer relevant anymore. That business is still there, but it still operates under our existing non-conforming uses there. And if it were to sell and change hands, that might change things, but it really, at this point, many years later, it just didn't seem like it was necessary there anymore. Andy might have more to say on that, but it was really for the Heilman office back in the day, and
Yeah, it all
John
came
Phelps
about-
added this, and it just kind of seems no longer necessary now.
Yeah, it all came about because of one office building on the corner of Central and Second, the Heilman office, and that was where it all originated from. So, and it was only because of when they burned down, and then they had to rebuild.
Right.
So, that's where it came from.
All right. Next suggestion, edit, comment, question?
This one's a little esoteric, but it might be worth, it might have just been an oversight. On page 31 of the PDF 24 of the document, in the WB1, why did wholesale light assembly and light manufacturing get moved from conditional use to permitted use? Because in WB2, it was already an administrative CUP, so it made sense there. But it wasn't, it didn't say it was an administrative CUP in WB1, so just to move it right to permitted just seemed a little unusual.
You know, I mean, it's one of those ones that could go either way. There's already some of those uses there currently. You know, just north of the tap house, there's that little semi-office park, but there's some uses in there that you can do wholesale manufacturing. One of the things that we're dealing with is the loss of our industrial zone properties through the city and then converting those things into residential uses. There's limited areas for those things to operate in, and we added some very strict standards on how those things can operate in there. And so it just seemed like one of those kinds of things, kind of like in the B2, where as long as they meet these conditions and they don't disturb their neighbors, you know, they have adequate, you know, protections on outdoor storage and all that stuff, then is it really bothering anybody? You know, I mean, I guess it's kind of a policy decision, but it's one of those areas that has had those kind of mixed uses over the years, but a lot of them have been grandfathered in or, you know, whatever. But
Yeah, cool, no change, thanks.
Okay, next. Anyone?
I'd like to go back to page 86 on 11-7-2 and strike the word zoning.
Just to be clear, you're talking about 86 as it's numbered on the physical page, not the PDF, right?
Yes.
All right. Yeah. Just, this is confusing to have the PDF and the other pages numbered. All right, is everybody in the same spot? Okay, go ahead, Phil.
Well, the reason for that is it has nothing to do with MLUPA on the zoning. And building permit should be in compliance with all ordinances and regulations of the city, not just zoning ordinances.
Okay, say that all one more time, please. Can you say all of that one more time, please?
Certainly.
Thank you.
Striking the word zoning, because all building permits should be in compliance with all ordinances and regulations of the city, not just zoning.
I'll second it just so we can discuss it for a second.
All right, thanks, Mike. I see where that's problematic, yes, to have zoning in there because we do want all ordinances, not just zoning ordinances, to be complied with, so I'll support that.
I don't mind supporting it, I just assume it was zoning simply because this is the zoning document, but it doesn't hurt to take it out.
Okay. All right. All in favor of removing zoning prior to ordinances? Half? Okay, one, two, three. All against? Okay, 1, 2, 3. So there we go.
so, yeah, it fails for lack of a majority, basically.
Wah, wah, wah. Thanks. Okay. All right. Thank you. And I would like to look at, this is page 88, the 88 that's on the bottom of the page, not the PDF. This is 11-7-6 appeals. B4, the number, yeah, B4, not the word, but the letter and the number. The zoning administrator must fix a reasonable time for the hearing and give notice. And I understand what's been stricken, but I would move that we add the notice is given on the website, I don't know what we call the project site, where you can look to see active projects on the,
Yeah, I mean, we're not, throughout this, we're not making any specific code language with regard to notifying on the website. That's something that we're gonna do and as part of our public participation plan as a bonus, but we're not putting it in the code. But yeah, I mean, as far as putting a notice on the property, we could do that, but it might be more specific in number 5 where we talk about the mailing notice that we do for appeals if it's specific to a particular piece of property, because not all appeals are specific to a piece of property. And so there's appeals over zoning administrator decisions that might affect everybody in the city. It's not specific to a piece of property, but if the appeal's over a specific piece of property, then we're notifying the neighbors. And I mean, at that point, we could also put a, sign on the property as well. But
okay, so if it is an actual physical piece of property, you're saying, yes,
yeah,
those
number
things
5 says when
will all
appeal
happen.
concerns a particular piece of property, all property owners within 150 feet of the subject property must be notified by mail at least 15 calendar days prior to the hearing. And so, I mean, that's been our standard procedure for appeals. That's above and beyond what state law requires. It only requires notice in the paper, but we kept that in there, just the way we've done it in the past.
It's all stricken on mine.
That's on number
On
5,
f-
B5?
On 4. On 4, it's all stricken. On 5, it's still there.
Yeah, well, the newspaper notice was stricken because state law is different than how we had it, and this was, Angie, I had some other language in there, and she basically, her comments were to just reference state law onto how the newspaper noticing went, because it depends on the type of appeal, it's different, so.
Okay.
That was an Angie change, and then we just kept in the way it's been done on number 5, so.
All right, then I do not make that motion. I rescind it.
I'd like to make a motion on page 87 on B9. It says, and add after city council or planning commission. So either one can make a grant a permit.
I have a question before a second on, or I guess I'll second that, and then I have a question. If there is an appeal to us, then could we be granting a permit on an appeal?
That's a good
Technically?
question. I don't know if, it'd be technically overturning a administrative decision, but staff would still issue the permit in that case. That'd be an Angie question, but, because it says ordered by the Community Development Board, which was, and of course, your decisions are also appealable to the city council, so you may or may not do that, but I just was struggling to find a situation where you guys would grant a permit. It was even now, you don't really do that.
Yeah. All right. We'll just go ahead and vote on that unless anybody has question, comment. All right. All for adding or planning commission to grant an appeal, to grant on appeal, raise your hand. Okay. All right. Motion fails. Thank you. Okay.
I have addressing the concern about phased versus concurrent, and so I think it's a legitimate thing. Maybe if we change some language, it might help. So this is on page 104 of the PDF, 97 of the printed version. Bear with me one sec. Come on. Okay,
What's the reference section?
the reference section, should have had that written down. One sec. And now I'm lost. Hold on.
Because the pages are probably going to be different depending on who's looking.
Oh,
at
yeah.
it.
So number 8 at the very bottom of page 97, printed, page 104 PDF.
Are you talking about?
Timing, phasing, and cumulative impacts.
Okay.
Got it? So, just briefly reading, where applicable, required improvements and services must be provided concurrently with development or phased to ensure adequate service levels are maintained over time. To assuage the concerns about that phased is too vague, I'll make a motion to replace phased with phased in concert with the phasing of the project. Realize that's a lot of phases, but phased in concert with the phasing of the project.
And again, these are just conditional use permit criteria that we evaluate when we look at that. It's not a specific code thing. These are just things that we would review when someone submits a conditional use permit. Those are some of the findings that we have that required improvements and services are provided concurrently with the development or phased to ensure adequate service levels. So, I mean, it's not a specific code requirement, it's a review criteria, just if that makes any sense. So that's what we use when we're evaluating, the impacts of a project and whether or not it meets certain things. And a lot of that stuff's in the engineering standards, if we're requiring them to put in infrastructure or things like that, the specifics of that stuff. But, I mean, I'm not opposed to your amendments either.
I'll second that because I do think that it helps with what we've heard from the community about concurrency and timing of projects. So I'll second.
Just following up, this is just
This is not talking about subdivisions, though. This is talking about specific projects. Because phased subdivisions is a whole different beast than this is a conditional use permit. So
That's
just
true, too.
FYI. But
maybe we can make it,
I mean, there could be a project that comes in as part of a PUD or something that has phased portions of it. So maybe it would apply to that. But
Yeah,
that
this
has
is-
its own criteria for that. So this is really just for conditional use permits, and there's not, I'm trying to think of any conditional use permit that had a phased portion of it over the years, and I'm struggling to find one, but.
I feel like we've had a lot come through that should have happened, and then they come back through and ask for something different, and they
Typically,
never come to
getting started is
fruition.
the hardest part with those things, If they
Yeah.
don't do them in 18 months, they expire, right? Same with the PUD.
But
so.
that's part of why I think concurrency, even in those types of things, is so important, even if it's not a subdivision. If you have a PUD and somebody does actually go forward very quickly, then you want all of that to happen with the correct timing.
Yeah,
So-
but just certain things like, landscaping is as a requirement, and with a conditional use permit, sometimes we'll require that, but because of winter, they can't install it, so they bond for it. And it's kind of like being phased in, where we make sure that it's all installed at the end of the day, but it isn't put in at the beginning or the project just because it's winter or impossible to put it in there. And there's other things like that, street trees and stuff like that, or even pouring concrete in the winter sometimes can be very difficult, but.
Mike, can you say that wording that you were suggesting one more time?
Sure.
Just a few words is all you wanted to add, right?
Changing simply phased to phased in concert with the phases of the project.
That makes sense to me. I mean,
In the unlikely event, just to speak to it, in the unlikely event that there are projects that are stretched out over time, it would be reasonable when assessing the conditional use permit to look at it and say, it's okay, it doesn't have to be, it needs to just, it can be done in steps, but only if it matches the steps of the project as, so it might be overkill, Dave, but that's the motion.
Yeah, my only concern if it would impact, and again, it's not a criteria for approval. I mean, it's something we look at as part of that, but it's not necessarily something that we would say, you know, it's not a do or die criteria. It's part of the approval review where we're looking at, does this meet the criteria? Because the specifics of a lot of that infrastructure installation is, you know, in our engineering standards. So, but yeah, I don't mind the language if you want to add it, so.
Dave doesn't mind it. Let's take a vote. All in favor of adding phased, what, as Mike said it, raise your hand. Okay, 1, 2, 3, 4. All right, so 5-4, and Mallory, are you opposed? Yes. Okay. 5-1, yes, thank you. All right, let's.
Going back to page 91,
Okay.
11-7-8, letter A, for conditional use permit requirements, after expanded, add nor may any proposed development.
Okay, we're on page 91 of the actual document,
Conditional use permits.
conditional use permits, letter A.
I'm sorry. After the word expanded, add nor may any proposed development.
Phil, is this in A, B, or C? I'm sorry.
Pardon me?
Is this in 11-7-8 A, B, or C?
A.
A, okay.
We'll get to B next. Huh? Yes. No structure, building, or land will be used, constructed, altered, or expanded, nor may any nor may any where a conditional use permit is specifically required by the terms of these regulations until the conditional use permit for the use has been issued by the zoning administrator.
So what was the specific change, to take the word expanded out of there and do something different? I
No.
couldn't hear you.
Add nor may any proposed development.
I think it's nor may any proposed development be approved where a conditional use permit is required.
Thank you.
Hey, Phil, what are you trying to get at?
Well, this puts everything into conformance with MLUPA, the section 76-25-305. In other words, the Whitefish zoning regulation should conform to MLUPA.
Just to move it along, I'll second it, but I'm gonna need to know why, what's written here doesn't comply with MLUPA. I just don't have that off my fingertips.
Just to make sure that it does comply. So, in other words, the procedures for the planning administrator are described at MLUPA, the 76-25-305.
Phil, I think it'd help if you, again, repeated the specific wording that you want to add to that, because a lot of us are confused, at least I am.
No.
Dave, from your perspective, do you think that the way it's written, it doesn't comply with MLUPA?
No, I think it does. I mean,
Okay.
I'm still trying to figure out what exactly he's proposing to add in there, but he's talking about proposed projects. And I don't see where we could say no project can be proposed without it. People can propose a project, but we can deny it, but it has to get a conditional use permit. So I don't know how you
Okay, with,
keep somebody from proposing something, but used, constructed, altered, or expanded when a conditional use is required until, conditional use permit's granted. So I don't know. I think it's the
Okay.
language we've had forever for conditional use permits, and seems to have worked all right.
Okay, I think I understand what this is talking about. It's, basically, if there's a proposed development, until the conditional use permit is issued, then no groundwork can start. Does that make sense? And
If that was something that you wanted to add to that, would not be the place to do it. This is just explaining when a conditional use permit's required. And we have another section in the code under Title II that talks about site development, prior to permits, and permit needs to be obtained. It's already in the code in a different area of the code that we're not really addressing with these changes. But
okay. Did you second this, just for discussion? Yes. All right. You can either rescind or we can vote. It's up
or
to you.
rescind.
Okay, motion rescinded. All right.
The next one is section B on your red line at the bottom, where it says after enabling, add reasonable urban development.
I'll second this.
I could add a little clarification to that.
You can, go ahead.
May I please? So what happens is this can avoid any interpretation that all development must proceed, even if it impacts cannot be mitigated. So only reasonable development should proceed. If impacts cannot be eliminated, then the proposed development might be denied.
I mean, how do you define what a reasonable development is versus unreasonable?
I understand that's subjective.
That would just be a court to say this is reasonable or not, right? But reasonable
That's why we have all
urban
those conditional
development,
use permit criteria that are in there,
yeah.
you know, that help evaluate it, and it's not about, I mean, it's just kind of a subjective term, whether something's reasonable or not, so I don't, not really sure how that would be defined.
Okay,
But I mean, that said, I'm not opposed to adding that word reasonable in there. I don't know that it impacts anything necessarily, but if somebody asked about it, I don't know how we would quantify that. There's no way to quantify it.
okay. Do we have a second? Did I second? I can't, okay. All right, so it's been moved and seconded. We'll go ahead and take a vote. Do we want to add reasonable to enabling reasonable urban development? All four, raise your hand. Okay, so against, 1, 2, 3, 4. So that fails 4-2. All right. Moving ahead at the speed of turtles.
Could I take us back a couple pages?
Yes.
Just glancing at my notes here. Yeah. And I guess I don't have a specific motion on it. It's more that question that could lead into a motion. On document page 85, PDF page 92, under the daycare, it said 1 space per 8 adults and supervised children, and then no parking is required for childcare facilities licensed or registered by the Montana Department of Public Health and Human Services. And I'm wondering if we're kind of making a distinction, like if somebody has an informal at-home facility versus something that's registered. Anyway, if you could speak a little bit more to that for clarification, that would be great. Thank you.
Yeah, I mean, that was our previous standard. I think, you know, I mean, there are people that do home daycare, but yeah, I mean, if it's licensed by the state, I think there's a certain number of kids. I think it's 8 or more, but I'd have to look up the state law to determine that. But if you just give me a couple minutes, I can work on that while you guys talk about other stuff. But I'm okay with deleting that if it's not necessarily the parking requirement on the top of that, so.
Was the line, just to sort of clarify what we meant by a daycare, was
Well, we added that
what?
language about the state license, because that state law requires
Okay.
that we not require any parking if it's a state licensed daycare. So-
Okay. But then the line before it is the 1 space per 8 adults. I guess that's where
Yeah,
I
I mean,
got
that's what's been in there
confused.
previously, and I don't know if there's daycares that would qualify that aren't state registered. I guess there might be, if someone's doing it in their house and it's less than what the state limit is, do we really care anyway? Because it's such a minor thing, so. Yeah, in that sense, I would. What's that? 12, yeah, 12 or fewer, so yeah, I mean, I guess that'd still be a state licensed daycare, right, so. Oh, so 12 or more kids is a required.
I'm good either way. I just found it a little confusing.
Well, that's a good
but-
question. I mean, it's something that popped up in my mind a little bit, and then I forgot to pursue it to go down the rabbit hole when I was doing these changes, so.
All right. I'm okay with it. If you've ever tried to park at a daycare, even if, no matter how many kids are there, it's difficult, so, yeah. I think it's fine to be in there. I'm all right with it. Okay, moving forward. Next.
Moving forward to page 92, under section 11-7-8E1, I'd like to add a paragraph Notice of the initial application must be immediately placed on the city website in a clear and searchable manner and be placed in a conspicuous manner on the project site. As to all notices by the city, persons or groups may file a request for continuing receipt of all notices issued by the city.
I'll second.
What page was that on again? Sorry, I was
Page
still.
92, 11-7-8, subsection E1.
Can you repeat the change as well, please? I was also,
What's that?
I'm just wondering if Phil could repeat the change. I was still attempting to find.
The addition would be noticed of the initial application must be immediately placed on the city website in a clear and searchable manner and be placed in a conspicuous manner on the project site. As to all notices by the city, persons or groups may file a request for continuing receipt of all notices issued by the city. And these are just, simple notice procedures. And members of the public must have time to prepare comments and gather support. As it is, the 15-day comment period after first public notice is very, very short. It operates perhaps as an impermissibly short statute of limitations. In all fairness, the members of the public should be given this additional easy notice after the initial application is filed. This will be moving proceedings along a lot more quickly and as fair as possible.
So this, just so you could know where the language is, this is out of John Heberling's comments. In case you didn't have it, all that language is taken from John's comment on the second page, about 2/3 of the way down, on 3/4 of the way down. Motion to add 11.7.8, and so all the language that Phil just mentioned, the language to be added is there, and then Phil just reiterated some of John's points about
Yeah,
the
I caught
additional
that.
notice. So that's the motion, is to add that language.
Yeah, we'll just say that, this section's organized, to be very congruent with what state law reads and when the process is. There is a notification section in there, after the initial determination and how that's worked, but where that's being added in here is not congruent with that. But I do think that, we'd have to go through and verify that that's all congruent with, state law and how, we have a certain amount of time to review a project to see if does it meet all of our criteria? And then once we determine that it's a complete application, at that point, then we notify the public. Some of this stuff's going to change after July 1st of next year, and we literally can't ask for public comments. And so, it took a long time to craft this in a way that would be easy to modify in a year. It literally took about a week of figuring this out and trying to mentally wrap your head around it and then design it in a way that can be modified to be compliant with state law.
I think the intent of this is to allow the longest time possible, because we're now down to that 15 days.
Yeah, 15 business days, which is 3
15
weeks.
business days.
Right.
So if this is the wrong section, there may be a better one with notification. But is there a way to add that a notice of a filed application can be posted if it's, I understand that things can go wrong, and you said you have to go through the application and make sure before you actually say yes. But is it possible for the public to know that an application has been filed once it's actually filed and in the office and stamped? can the public know this has been applied for and now we can start looking at it?
Yeah, I mean, it's part of our process, and it's outlined again in our public participation plan. Once that project's submitted and we determine that it's a complete application, and that's when the clock starts, and then we have to send out a notice, and mail takes a week, so they have to have a full 15 business days to be able to respond, so it's really a month for them to respond, and at that point, once it's determined it's complete, we're gonna put a copy on our current land use website, and we'll put a notice on the property, and then we'll notify all the neighbors within 300 feet. And so, I mean, when it first comes in the door, we can't, until we know something's complete, we may not even be able to take it in. Typically, sometimes we have to refund people's money. You're asking for something that's not even allowed or whatever. I mean, we have to go through a review period, but sometimes we get a bunch of these in a day. We don't even look at them for a week, if we have other projects, so. It just takes time, especially now that we're gonna be shorthanded for a while. Trying to promise that we'll post it on the website as soon as we get it in. I mean, I don't think that's something that's reasonable for us to do. But we will do it when the notices go out and once we determine that it's a complete application and it's ready to go, which is how it's designed like it is right now.
All right,
Well, given that, I'll rescind.
okay, thank you. All right,
That's a good discussion, though, of the limitations of notice. I realize the motion's rescinded, but it's a good discussion to have about making every effort we can for public notice. So maybe not there, maybe not now, but that's something to keep in mind.
Well, I think that was inferred by Dave.
thank you. Yeah, I think we'll talk about that again. Maybe not us, but down the road, somebody will. All right. Yes, we're gonna take a 5-minute break. Okay, we're gonna take a 5-minute break. We'll be back. Let's see, right now it is almost 8 o'clock. It's 7:54, so we'll be back at 8 o'clock. Thank you all. All right, I think everyone is back. Are we ready in the back? AV guys, thanks. All right, so we'll call this meeting back to order. I have one thing I want to jump back to before we move ahead. Still on page 21 and 22, I know we made changes there, and that things will be settled in zoning later. But to keep in line with the place type that was issued for this area that I think we called O'Brien, Lupfer, and Central, where we said up to a fourplex, I would propose that we remove the language that says 19 or more dwelling units to protect us in this interim time.
So just remember that the R4 applies to all those areas on that map that you guys have that I provided with you on the table. It's not just the Lupfer neighborhood. There's R4 in 5 or 6 different places around town, large swaths of it, which is our highest density residential, where we've forever determined that that's where high density should go, which is why we talked about, you know, when we implement our growth policy update, that you look at that Lupfer neighborhood, change the zoning on that to conform with this, what the Vision Whitefish said, but we can't do it in one fell swoop because R4 is not just there, it's all over town. So just my 2 cents.
Yeah, we just have talked about carve-outs for Baker and Spokane and multiple areas, the manor that's there. But in this, well, that particular area that we changed back to heritage urban, I think. It's just concerning to me that this still says 19 or more dwelling units. So I would just propose, I think, because we have ADUs and duplexes by right, 18 or more dwelling units in this interim time before we get zoning established. I propose that we take that out and keep it at the fourplex as a maximum.
There's 2 things, Whitney, just to be clear. The 19 or more is a conditional use. The multifamily dwellings, 19 or more, is the third last bullet point. So that's a conditional use. I think we can safely say that no one's going to probably allow that. Is that what you were talking about, or are you talking about the multifamily up to 18 dwelling units up in the permitted uses?
In the permitted uses, yeah, up to 18, where it says single-family, duplex, triplex, fourplex, and multifamily up to 18. I think up to fourplex is what was decided, discussed, petitioned, and brought before us and the council. And those that Lupfer, O'Brien, Central neighborhood were reverted back to the heritage urban. So I propose that we remove this up to 18 dwelling units under the permitted uses.
I'll just let you know that the snow lot where we have Depot Park Townhomes has 22 units going in there, and that would make it non-compliant with our zoning. And we have not submitted a building permit for that project yet.
I understand the concern here, but really it's writing or putting in a new zoning district in a particular area. It's not changing the multifamily zoning for the entire city. That's the thing I think we're really concerned about, is this isn't just a neighborhood. This is the whole all the multifamily zoning in the whole city would no longer allow multifamily. It would be better to create a new zone district for a particular area. That's how you'd be compliant with the plan.
Yep, and that's what we plan on doing with the phase 2 of the zoning, and also putting in some very strict development requirements of how buildings can be built and how they fit in with the neighborhoods. But, you know, the zoning right now, it allow, you know, it used to have no limit on the number of units that could be built in there since 82, and just in 2019 or 2020, when we did the legacy homes, is when we put in a limit on there and made some conditional uses so that we could capture those things and make them do permanently affordable housing in there, which then the state took away from us. But there is many districts, and all over the viaduct, there's a giant swath of R4, which is where apartments are going in. The Ruiz project, it's the areas where we're getting affordable housing in the city. And so putting a limitation on four units on there would definitely preclude us from getting affordable housing in some of these other zoning districts around the city, because it applies everywhere, which is why we have to specifically look at that area downtown, put either an overlay on there or make the zoning different in that downtown area to be able to accommodate what the growth policy has established. And then that's one of the main things that this whole second phase of zoning is going to look at, that neighborhood, as well as some of the R2 neighborhoods over to Columbia Avenue, which is going to be different than the rest of the R2 zone, which is why we couldn't just do an easy fix in the R2 and make some changes in there. So it's just something that's going to take a lot more time to figure out what the boundaries of that are and add specific zoning to that. And there was no easy fix in the R4 because it's not just that downtown neighborhood. It affects a bunch of areas in the city.
Yeah, and I definitely it's not my intention at all to limit multifamily in the R4 completely, but that heritage area, that's what I was concerned about, and I know that this will take time, and that's also my concern, is the time between now and when that zoning will actually happen. But I understand it's a process, and I didn't get a second. So I just have spoken what I would like to say, and I'll leave it at that. Move on to subdivisions, or if there's anything else in this. Go ahead, Marty.
Just to travel back again, during our break, I spoke with Dave a bit about the childcare facilities, and I guess it is any facility where there are 3 or more kids who aren't related requires a childcare licensing permit. So I think it actually makes a lot of sense to strike the line on page 85 in the daycares. Sorry, I'm still scrolling as I'm speaking. Because that first little bit about the parking for, sorry, I'm still scrolling.
Top of page 85.
Top of
removing
page.
1 space per 8 adults and supervised children.
Yeah, that really wouldn't come up at all. It would be, pretty unlikely to need that specific arrangement. We would only be really dealing with childcare facilities that are licensed and registered. So I move to strike 1 space per 8 adults and supervised children.
Second.
All right, all in favor? Okay, passes unanimously. Thank you, Marty.
One other one, it was again kind of the question thing that I don't even know if I need to make a motion on it, but on page 105, and sorry, I'm scrolling as well now. Oh, sorry, document page 98. Right at the top there on L, burden on applicant. I was just wondering, so it says burden on applicant, the burden of proof for satisfying the aforementioned criteria considered for approval rests with the applicant and not the city council. Being as
Oh, yeah.
everything else is moving
Yep.
to zoning and planning administrator, I was wondering if that should switch
Yep,
to
it should be
zoning
changed. It was
administrator.
missed.
Okay,
Good catch.
then my motion is to switch city council in that sentence to zoning administrator.
I'll second. All in favor? Great. Thanks again, Marty. Gold star. All right. Moving ahead.
Alrighty. I just have this, I'm almost done with zoning. 51, and on page 51 of the PDF, which is 44 of the document, two zones actually, both the WB1 and the WB2. There is, in the front setbacks, vehicle and pedestrian ingress and egress may be allowed in this area up to a maximum of 40% of the landscaped area. In both those zones, that's crossed out, and I was just wondering why.
We have landscaping standards. I'm not sure why that was put in back in the day, but it's just always caused consternation. There was some specific standards in there about like berming and things like that that didn't match our code. We already have standards in our, over a certain number of units have to meet our landscaping requirements. It's just one of those things that wasn't congruent with our landscaping chapter and our public works standards, and it's like, we've always wondered why it was there, and it didn't really make any sense, so.
So vehicle and pedestrian ingress and egress is handled elsewhere?
Well, it's just, if someone's putting a driveway in there, I think the intent was that somebody couldn't pave the whole front of their lot all the way to the street.
Okay.
But we don't allow parking in the front anymore and stuff, so, our standards have changed over the years. It's just an artifact from
Got it.
back in the day.
Okay, thank you.
But good catch. I mean, it did change, but it's just one of those housekeeping things that, like, why is that there? And it's always bothered Wendy and I, and I don't know that we've ever, it's just one of those things.
Last thing for me from zoning, and this is a bigger topic, but it's the appeals process in general. So I'm a little concerned as of yet. The overall appeals process is on page 96 of the PDF, 89 of the document. So first thing is, if a planning commission decision is appealed by any party withstanding, then does it automatically go to city council? There's no approval step that I could find. So if we, as the planning commission, hear an appeal, make a decision, there's no screening for appealing that to city council that I could find.
I think there is some in state law. I don't know that we referenced it. Yeah, go ahead. Yeah.
In MLUPA, and I can't quote the exact section, but what it says is that when there's an appeal, it must be shown that the administrators, talks about the zoning administrator, that his decision must be made in error, and that you have to appeal it only on the impacts that were the new or significantly increased impacts that were not previously considered during the writing of the plan and the regulations. It's very narrow what you can appeal on. You can't just appeal everything. You have to show that he made a mistake in his decision, and that his mistake was involved with the impacts that he did not properly assess.
So work with me on this one.
But planning commission, it doesn't say. It just says you already hear it de novo. I can show you in MLUPA where it reads.
Okay, so just work with me. I don't know if there's a solution, but I just want to get this kind of on the record so that we're clear about it. I'm looking for, is there any barrier to somebody, the classic case, someone goes to the zoning administrator and Dave says, no, there's no way that's no good. And they appeal. Now, interestingly enough, Dave's the person who's then going to decide whether the appeal is valid, right? So you've got like two stops there. The planning administrator. does this, denies it, and then somebody appeals it.
Yeah, I mean, the appeal has to be based on
100%.
impacts that weren't, based on the code.
But
yeah.
maybe you think there's enough gray area. Eventually, an appeal's going to get to us. We know that somehow or
Yeah,
other.
I mean, you could be arguing about are they properly addressing the impacts? And I feel like, yeah, they're not properly addressing the impacts, so I'm going to deny it. And they appeal it, and then they try to make their case to the planning commission. No, we're addressing the impacts. We feel like they're significant enough. And then you guys agree or disagree, and maybe you agree, but then the neighbors disagree, and then that gets appealed to the city council. I mean,
So,
it's going to be the process is something like that,
right, just to clarify, the only concern I have is, it's a what are we doing here? What is our role in this question? Once something is appealed to us, we make a decision.
Right.
And that's a decision, it's not a recommendation at that point. However, if the applicant or the neighbor or you want to appeal it to the city council, there's nothing that stops that. So anytime anybody doesn't get what they want in an appeal process that comes to us, it is almost not guaranteed, but they can just go to city council immediately. And so the question, what are we doing here? What is the value of the appeal level coming to us if any of the parties can immediately because then there's no more question about was it an error, whether their impacts were considered, because everything's already been done.
My only comment was this has been a concern, and we've argued about whether MLUPA might end up slowing things down even more. We've had that argument, because before there was a public hearing, now if everything can get appealed and it has to go through court at the end, which takes even longer, is this really going to speed up the process? We didn't write it.
And
Yeah, and the question, is this appeal of a certain type of decision different than a land use case decision? Is it the criteria different? Because there is a whole section on appeals and a different section of state law under Title 76, but on MLUPA, yeah, there's still some questions out there of how process is going to work, but.
I don't have a solution, I don't have a motion. I just wanted to
Yeah,
clarify
I mean,
that was the case. Okay,
It's
thank
been
you.
a struggle just figuring that out, and
I think until the process is rolling and we start seeing what's not working, might have to be the time when either we go back to the state legislature, if they ask us and say, this is a problem, and they're probably only gonna, I'll speak for myself. I think they're only gonna care if it's slowing down the applicant's process, so it's balling things down more.
The only thing it's the aggrieved party, and there is a definition for that, and so they have to demonstrate that there's specific personal and legal interest, which is distinguished differently than general interest. So it's going to be like a neighbor. I think, it can't just be a member of the public. They're going to have to be able to articulate why they have a specific personal and legal interest in the decision.
People are really good at being aggrieved, but
Yeah.
thank you, that does
Yeah,
limit it a
but
little
we've
bit.
always said that's fairly general
Sure.
in itself, but
Makes
that's
sense.
state law.
Thank you all.
Go ahead, Mallory.
So this is just a general comment, and, maybe we'll get into this more in like the bigger zoning update. On page 96, on the PDF, and it's, number 6, it's talks about 200 average daily trips as for like the traffic impact study, and I was just curious, like where that number comes from. Is there a difference between like a multifamily development downtown Whitefish that's like near services and how we think about traffic impacts there versus if we're building an apartment building on the edge of town and how those traffic impacts like are different even if you have
Right.
similar numbers?
I mean, that 200 vehicle trips a day, that's out of the Public Works engineering standards on any project, whether it's a building permit or anything else, that they have to provide a traffic study and evaluate whether it's going to impact the level of service around that. I mean, there's certain parts of Whitefish that already fail on level of service in July, but it's just like, a church parking lot. Do you design it for Easter Sunday or is it for the normal Sunday? And that's something that I've talked to Craig about. Like in our engineering standards, we're going to have to be much more specific about how we address level of service, when traffic studies should be done, and, you know, because people will come and complain and say, well, you did that in March, not in July when the traffic's the worst. Well, should we be designing everything for the worst case scenario that's 2 months out of the year or for the rest of the year? I mean, that's some policy questions that have to be decided. But is it fair to judge someone's traffic thing on, you know, July 15th and under the big skies going on versus the rest of the year when it's like this and traffic isn't bad? You know, and that's kind of one of those things where everyone can use different things to argue things. And I just think that because there isn't really specific review criteria in the engineering standards, and that's something Craig's going to try to work on this fall. He finally just got a second in command hired, and so hopefully they have time to work on that. But it's something that, you know, so that we can evaluate the impacts, because I feel like every project, that's the thing people are going to challenge is the traffic impacts, right? And it's normal because, you know, every new thing is going to generate a little more traffic, and some more than others. And you know, and I want to be able to say, hey, you know, give me some ammunition to be able to deny things that I think are an issue that are really going to cause problems, you know? And so Thomas and I worked on some additional language in here talking about, you know, a 20% increase in average daily traffic or 1,000 more trips, just to try to give some more ammunition in the code. And not only that saying that we have some criteria for these impacts, and so we can, you know if something's going to really create an issue or not, because, you know, I'm more than happy to, you know, deny something and kick it to you guys to hash it out instead of me taking all the heat, you know, or whoever my successor is, you know, but, yeah.
Okay, thank you.
Anything further on this section? All right, we're ready to jump ahead to subdivisions. Item number 2. Tell us what's on your heart, Mike.
I have really trivial things.
Go ahead.
Subdivisions. First thing, a question, page 2 of the PDF, 2 of 4 of the printed document. Go back up to the top and get there.
I'm sorry, Mike, what page on the PDF?
Page 2 of the PDF, and also it's listed as 2 of 4 on the printed document. It's in the final plat section.
Do you have the reference number of the
This
section?
is up in the very top and in the background information. It's just on second page of
Oh, the
subdivisions.
staff report?
Yeah, the staff report, yeah, sorry. You guys, might not even need to look this up, Dave. It's just simply, the final plats subsection remains the same. Final plats go to council on the consent agenda for the mayor or deputy mayor signature on the Mylar. It's on the consent agenda. Is this a standard thing? They can pull it off the consent agenda and discuss it.
Yeah, I mean,
Nothing changes there.
I mean, again, at the point it's that final plat, all the, you know, improvements have been put in. Like with the city, you know, Public Works has signed off on, you know, the roads, the sidewalks, the street trees, all the water and sewer. Everything's installed at that point. You know, their lots are basically ready to be divided, but, you know, until final plat goes into effect, you can't sell them because they don't exist yet. I mean, that's at the final stage. I mean, and the council does have to approve those things under state law, but, you know, I mean, I could see people that are upset about something coming into those meetings, and that's like their last opportunity, because the council has to ultimately approve it. But it puts the council in a very hard position because the developers just spent $4 million on all these infrastructure improvements, and then only to have the council somehow, you know, deny the final plat. Because, you know, the idea is once the preliminary plat's approved, it's gonna go in because they're putting all the stuff in there, and the final plat's just a, you know, more of a, you know, formality at that point where the mayor has to sign it and public works director has to sign it and I have to sign it and the city attorney has to sign it, and then it goes to the county recorder's office and it gets recorded, and then those lots get created.
What's different here is that this could be the first time this council sees the project.
Correct, because under MLUPA, they're administrative, right? But up until that point at the final plat, but still in order to create that, I mean, it's a little bit of a weird glitch in it, in that,
From a
And
practical,
it's been brought up by other planning directors around the state that it's kind of strange that that's the point, that, you know, potentially people might show up and complain because they didn't get heard through the other process because it met all the other criteria or whatever. So again, it just put a kind of a strange onus on the city council. But on the flip side, you know, that's why those, you know, they're always on the consent agenda because it's already a done deal at that point, pretty much.
from a practical matter, it'd be
Yeah.
very rare to pull it off, given all that.
Yeah,
Okay.
exactly.
That's good. That was one. 2. Page 35 of the PDF, page 31 of the document. I just think there's a typo in C5. And it's not just a typo, like a misspelling, but it's an important word. So, 1 second. Yeah, number 5, after a preliminary plat, so you can say that easily, is approved, the local government may not impose additional conditions as a prerequisite to final plat approval. And it says is, should that be if the approval?
If,
Yeah, okay. Wow. I just, because I was trying to understand it, I was like, So we
Yep.
don't need a motion for the change is to if.
we can blame Wendy for that, so, no.
That's what you do.
And me for proofreading it, and not catching it.
We get 6 months to blame Wendy.
That's why we have other sets of eyes like you guys checking things, because we had a short amount of time, Wendy and I, to pull this stuff together. And, yeah, it was a slam it out.
This next one, I just want to go back. It's a question, but it seems important. It's about annexation, and it is on page 8 of the PDF. And, did I lie? Hold on. 1223. Just that change, the added, so if a property proposed for subdivision lies outside the city limits and proposes to utilize the city services, the property must be annexed, and then you added and assigned zoning into the city limits prior to submittal. Is that, was that an MLUPA thing, or is that a?
It is, I mean, because there's county zoning, we can't administer and enforce county zoning, so it has to be changed to a city zoning. I do think the wording of that is awkward, though. It should be annexed into city limits and then assigned zoning after that. That's how it should read. Because we have to assign a city zone to whatever comes into the city that's appropriate. And there's a process for that. And, you know, if it's what we've already anticipated and it's an equivalent, then there's an expedited process for that. But if they want something different, then they have to make the case to the planning commission and the council for whatever different that is.
But is this a change, or were you just clarifying the language?
I think we're just clarifying the language. But it does need to be fixed, because it's not, that end assigned zoning should be after city limits.
Oh, I see, yeah. So that is that a motion worthy, Madam Chair, or is that just to simply change where that clause, moving that clause from till later in the sentence?
I mean, you should make a motion and, yeah,
I would say Alan could just do that.
I mean, I'm the
Right.
one working on
It's-
this, but
Or
it's still
Dave.
cleaner if you just make a quick motion and everybody
Okay.
agrees, because that's how you did everything else in this.
Motion it up.
I will make a motion to move and assign zoning to later in the sentence so that it reads better.
Second. All in favor? All right, unanimous. Thank you.
That is all I have in subdivisions. It's very clean.
I had a question while we're in this general area of subdivisions. It is on the PDF, page 6, and then it's kind of that early appendix, page 2. It's just a question. I was just wondering about the sentence that had been struck. The city may coordinate or enter into land use interlocal agreements with other jurisdictional agencies to guide decision-making.
What section number is that?
Yeah, it is on 12-1-4, formerly, yeah.
So, I mean,
Under A, I was just curious.
yeah, I mean, in the past, we had interlocal agreements where the city administered zoning and subdivision outside city limits. You know, we don't have that with the county anymore. I think it's some old language that was in there prior to that that's never got removed. I mean, I don't think it's terrible to remove it. It could stay in there in case we ever somehow got another interlocal agreement with the county, but that's very doubtful, so, yeah.
Well, are we working with the county on lakeshore things right now?
I mean, we've put
As
out
far as,
a you know, truce flag to try to see if we could work together, but I don't know how well
Yeah.
that was received by the county commissioners.
maybe if we put this sentence back in,
But
they'll
this
say,
is specific
"Oh,
to subdivisions, not the lake shore, so.
a subdivision on the lake, though? What if, I don't know.
And the state law already allows the city to have interlocal agreements regardless with any entity for any purpose, for the most part, for other local government jurisdictions, so it's just redundant, if anything.
Okay, thanks, Dana. All right, anything further in this section? Go ahead, Marty. Or in any other section, keep on.
I had a couple things, mostly they're just really, really small things that I thought were typos, which is not like a dig on anybody. This thing is huge and it is overwhelmingly doesn't have typos. But I don't know if it's worth it to like go through those point by point with
I mean, if it's
everybody
confusing
here.
to you, and we just want to make sure it's clear to the general public, so if you have something that could be worded better, I mean, I think it's good.
Okay, only one of them that was confusing to me, and the rest are really small, and I could just email them if that would be preferable. Or if we don't really care, that's fine too. But in terms of the one that I was confused on, it would be on document page 91. Or sorry, PDF page 91, document page 81. And actually, I don't know the answer to this or not.
Is this in the definitions?
Yes. Sorry, let me, okay. This where it was? I might have to, okay. Oh, here we go. It was just, there were two references to Lost Coon Lake, and I wasn't sure if that had been renamed or not. Because when I looked at it on Fish Wildlife Park, it was still Lost Coon Lake, and then when I looked at it on Google Maps, it was Lost Loon Lake, and I know that that was a whole thing, and I forgot that Frank wasn't going to be here, and I feel like he lives out there, and maybe could have
Yeah, I
clarified.
mean, if there is a reference to it, we should change it in there. I mean, I know this, the lakeshore regulations had the old name in there until we revised them last year, and, yeah.
It's in the mean high water mark section,
Thank you.
and at the
Did I
bottom
get
of,
my pages right?
PDF 91, document page 87, right at the very bottom. And there's two
Oh, it's
references.
both in there. So it didn't strike, it said lot. Yeah. That'd be an easy fix.
Yeah, just go ahead and make a motion.
Is it,
Two.
do we actually, is it, has it been changed to Lost Loon Lake? Is
I
that
mean,
the
we changed it in
official-
our regulations. There's
Okay.
certain, the state has their own maps and stuff that who knows when those will change, but all our references changed it, and I think we changed the sign as well.
I think we changed the road legally.
Yeah.
I'm not sure about the water body. I thought we went through the process, but I can't recall.
Can we still change it?
So you're right, it's referenced, both of those are referenced on multiple maps. It's, even the road is referenced as Lost Coon, sometimes it's Lost Loon. We put a petition into the county to change it to Lost Loon Road, Lost Loon Lake Road. Just for the road, but not the lake, I believe. They accepted the road, but I don't know that they accepted the lake. But the other name is also still referenced in some of the Fish and Wildlife, which is what the original lake name was that we won't mention today. But
Do you guys have any, I mean,
I'm
does one
happy to
make more
change it.
sense than the other? Or like, would one be better for consistency at the state level?
Let me,
It was mainly just a question at this point of which one to use.
yeah, does somebody look in the lakeshore regulations to see how we defined it in there?
For the purposes of the growth policy, can we not just have a consensus to change it all to Lost Loon? Because it seems like it's moving that way, and since this is a 2045 document, may as well just go ahead.
Let's be on the right side of history on this one. It's in Google Maps, it is Lost Loon Lake.
Yeah.
I believe that the petition was approved by the court for the change to Lost Loon Lake. This is a Flat Beacon article. It's
Yeah,
been a
and-
while. I think COVID happened since.
And we
like,
call it
since
Lost
then.
Loon in the
Oh, it
lakeshore
was
regulations, so I'm happy to change it. Yeah, I think it's a
Okay.
good change.
We've got Lost Coon Lake in a few places in our lakeshore protection.
Well, we changed it. Does it still come up?
Came up,
Under definitions, it says Lost Loon.
and definitions, yeah,
It says loon in definitions.
Lost Coon Lake.
You must not have caught all of them.
I motion to change Lost Coon Lake to Lost Loon Lake on page 87, and then it also comes up again on page 202 of the PDF. So in the two places that it's referenced, I motion to change it to Lost Loon Lake.
I think the second section of that is just the clean version of the code, so.
There are two individual uses
In the marked up one? Where's the other one at? The document page.
It's Appendix B, page 56, if that's helpful.
Thank you.
Page what?
Appendix B, page
Oh.
56.
I was wrong. It is just one in the marked up version
Yeah, the other
and
one's
one
on
in
the
the clean
version.
version.
Yep.
My mistake.
So
All right, I'll second that. All in favor? Great. Unanimously passes. Anything else in? Anything else in item number 2? All right. Andy, anything from you? Okay, Marty, you're good? All right. Mike? I'll come back to you. Keep on looking. Mallory, you're good? Phil, anything? You doing all right? Okay. All right. So we'll give Mike just a couple of seconds to make sure he's cleared up, caught
Just-
up.
I'm just taking an extra second because we got the public comment later. So I'm just going through a little bit of their comments to see, it'll take 2 minutes and then just to see if there's anything material there that we want to address. John stuff was all going down. I don't have anything else.
All right, so we have given direction on both of these two items. Do you guys prefer that we give some sort of formal?
Two separate motions to pass this along to the city council for each of the two things. Yep.
Okay, so I will
With
make.
the changes.
Okay. Does anyone like to make a motion? I don't like to as the chair. I can, okay. I move to send to city council an approval for WZTA 26-01 with the changes as approved by the commission.
I'll second that.
Okay, all in favor? Okay, unanimous. And for number 2, I'll go ahead and move that we send WSUB 26-01 to the city council with our recommendation with the changes as we have voted.
And I'll second that one.
All right, all in favor? Okay. Matters from the board. Phil, anything? All right, Mallory? Okay, Mike?
You know, it's not just blowing smoke. It's a really nice job on this under really tight timelines and circumstances. You made it easy to get through all these changes, so thank you.
Marty?
Yeah, I agree with Mike. Yep.
Thanks for having me.
Any,
This goes to the council on May 18th, and we just need a poll of, make sure that you guys are available on May 21st, which is your next meeting, which there are a couple items.
anybody know they will not be here on the 21st? You will not be? Okay. All right, and then we'll just wait and see who else is. Thank you, guys.
See you then.
Have a good night.